Keeping an eye on that breaking news from Capitol Hill. Just moments ago, U.S. District Judge Tanya Chutkan unsealed the records and evidence filed by special counsel Jack Smith in the 2020 election interference case against former President Donald Trump. Judge Chutkan ruled the public should have access to all parts of these proceedings. Trump's legal team argued the files should be held until after the election. But the judge refused, saying withholding those documents could be considered election interference on behalf of the court. Her decision comes just 1 week after the brief was made public with some redactions. CBS News legal contributor Caroline Polisi breaks down this case for us. Now, I know you just got your hands on the documents, Caroline, and they are lengthy. What are you going to be looking for when you're going through them?
Yeah, a lot to go through here, Liz. I would just note that there are still heavy redactions in this appendix. It's hundreds and hundreds of pages. What I'm seeing mostly here are tweets from the days leading up to January 6th, as well as some travel logs, some fundraising logs, and then some January 6th congressional committee evidence. And now, remember, this is the appendix to Jack Smith's filing in response to the Supreme Court's decision, the immunity decision, a really landmark decision conferring criminal immunity on presidents. And this is Jack Smith's response. Tanya Chutkan had ordered the parties to really sort of preview their evidence so that she could make a determination as to which actions really fell within that scope, the parameter of either immune conduct for presidential values, issues, versus purely private conduct. And this is Jack Smith's salvo to show that all of the counts in his indictment are private conduct and can move forward.
And Caroline, both the special counsel and Trump's legal team continue to debate whether this indictment is protected by presidential immunity. The defense says they'll once again file to have the entire thing thrown out. What are the arguments here?
Yeah, and they've already done so. Now, what's interesting about that argument is that the Supreme Court specifically told this lower court, Judge Chutkan, to review, go through piece by piece, essentially, the evidence in this case. Jack Smith actually re-indicted the case after the Supreme Court decision, specifically so that he removed any even potential conduct that could, he felt, be covered by the decision and be immune from prosecution. And so, again, Trump's lawyers are making this argument that they would like to throw the whole case out, that every single allegation of this indictment and every single piece of evidence that the government wants to produce is in fact covered by the presidential immunity. They essentially argue that everything he did was as part of a core presidential act. And I don't think that's going to fly. Remember, they even wanted this unsealing, the appendix unsealing, to happen after the election. Judge Chutkan said absolutely not. Politics plays no role in her courtroom, and it would be unsealed because there is a presumption that the public should see these types of things under the First Amendment. It would be unsealed in the normal course of any criminal defendant's case, and she's doing so here.
Caroline, I'm going to be really interested to hear your thoughts after you had some time to dive into those documents.